Hello, everybody. Thank you very much indeed. My name is Elizabeth Moroney. I'm a partner here at Clifford Chance, and I'm delighted to welcome you all back, I hope, for the fourth David Vaughan lecture on antitrust litigation. I'm going to leave David to introduce Nick, but Nick has just pointed out to me that in a post-truth world, we have a horrible truth.
Having an identity crisis.
I think Peter isn't here. He was here last year. So with apologies to Nick, who is not Mr Justice Ross, we don't care about truth anymore, but he is going to talk to us about experts. So yes, we'll put that. There we are. Apologies. David.
My name's David Vaughan. This is I think the fourth, what I call the memorial lecture.
You, not me.
Whether Liz does, I don't know. And it's something which we've done together with Clifford Chance over these 4 years. And it's been a great success, and I'm very grateful to Clifford Chance doing it with us. Nick Green is the speaker this time.
No, I'm not.
And Nick was in chambers with us for a long time, and we tried to remember when Nick first came to chambers. It was he'd spent time with Moncton as a pupil, and then he was with Claire Tritton for a short time, and then one day Nick said I invited him to come and have tea, but by the time he'd finished tea, there was no doubt that what he had to do was to come to Brick Court as a member. He was a tremendous success right from the beginning in EU law. He'd been academic dealing with the EU law at Southampton and various other universities, and so he knew a great deal about it, and about EU law, and he developed a tremendous practice in that field, and remained really the outstanding practitioner in EU law, competition law, and in regulatory law over the period, and we're immensely proud of what he did. And then since 2013, I think he's been a judge and has done almost no EU law at all in that period. A little bit but not substantially in that period. But what I'd like to do is to welcome Nick Green very much, and we're extremely proud of him, and very pleased that he's agreed to give this lecture. Nick.
Thank you very much, David. A percentage of you, the young at heart, will know where Gallifrey is. Some of you plainly do. According to the internet, if you were to check, Gallifrey is located in a binary star system within the constellation of Castor-Boreas. It has galactic coordinates, which you may wish to note down, are 10, 0, 11, 0, multiplied by 0.2, measured by galactic zero center. None of these sources, I hesitate to add, have been verified by the provision of reliable source data or expressed in peer-reviewed academic sources. There is, however, a growing body of expert evidence to suggest that out there, in deeper space, there are other experts contemplating the existence of experts on other planets, such as on Earth. You laugh. This arises because a rapidly developing body of scientific techniques is emerging, which are devoted to determining and identifying the existence of stars, and in particular the planets that circle them. They're called exoplanets. Every planet that circles a star moves in a way that, in some way, shape or form, reflects that planet's gravity. And it means there are various variations in the speed, or what's called radial velocity, with which a planet moves to and from or away from Earth. That radial velocity is measurable from Earth with considerable accuracy. These can measure the radial velocity of planets up to 160 light years away. Now, sometimes this produces false results, where a host star, for example, has multiple planets. You can get false data. Now, recently, a new technique has been developed called the transit method. If a planet crosses, in other words, transits, in front of its parent's star disk, then the observed visual brightness of the star drops by a very small amount. And that, of course, depends on the relative size of the star and the planet. Now, between 1995 and 2005, 95% of the discoveries of planets were achieved using radial velocities, and only a handful via the transit method. However, now the transit method has been established, it can be applied with relative ease, and it generates predictable and accurate results. It is now the dominant method of finding other planets. Now, all this is extremely useful to identify planets which might harbour life. NASA estimates that within the Milky Way alone, there could be 1 billion, in fact, between 1 and 10 billion exoplanets. So the source data for this evaluative technique is enormous. Now, recently, 2 researchers at the University of Columbia in New York have deduced that if we on this planet are, as in fact we are, capable of measuring the size and the mass of far distant planets, and we can begin to assess its suitability for life, then it must follow that the same is true of any other self-aware civilization. After all, we have progressed from a time when water mills were the height of technology to, in a metaphorical blink of an Einsteinian eye, to the point in which we can measure the relative velocity, mass, and radius, and indeed some of the chemical compositions of planets 160 light years away. Now, they've deduced, these scientists, that any other advanced civilization that had the same technology that we have got at the moment will, by definition, understand that the presence of their planet and that it is habitable and contains civilized life will become evident to other planets. Researchers on Earth, that is, have worked out that with the technology we have at the moment, it is possible to either cloak and protect or broadcast our presence through controlled laser emissions. Such emissions will distort the light which comes from transiting planets. So any civilization 100 million light years away, doing the same as we are doing, will know by looking at the artificiality of the signals coming from that transiting planet that there is civilized life there. And indeed, you can send a laser emission with an extremely small amount of power. A typical power that you would need to cloak the entire Earth, in other words, to camouflage it, would be 30 megawatts for 10 hours per year. And if you wish simply to alter the signature coming out from Earth, the signatures associated with biological activities such as oxygen, you would need a laser with the power of only 160 kilowatts per transit. Now, it follows from this that with relative ease, a civilization can broadcast its technological capabilities to us. The interesting thing is we have now collected on Earth an enormous amount of technical data about transit planets. And what the scientists have now started to do is to survey this vast array of data for what they describe as artificial signals. If you want to imagine a distant exoplanet, Gallifrey, unless we find a way of exceeding the speed of light or time traveling, the conversation that might exist as the two of us send these artificial signals might, of course, be a little stilted. From Earth, it would go, "Hello, is there anyone out there?" 150 years later from Gallifrey, splurg, bang, bong, bling, meaning, yes, we're on our way, put the kettle on. The paper that analyzes this technology is, of course, on the internet. It starts with a narrative explanation of the concept that a layman can understand. And if you don't understand the terminology, for example, radial velocity, you just type it into Wikipedia and it comes up with a very nice explanation in moments. But of course, quite rapidly, you get past the narrative and then you get the maths. And it goes on for pages. And it proceeds well beyond the judicial capabilities, which is approximately 2 + 2 = 4. But judicial limitations apart, the principles of maths, which we are assuming this distant civilization will have, are universal. There isn't really much doubt, but that if we have the technology, then one of those 10 billion exoplanets out there will have similar technology based upon the same mathematical principles. Now, this paper was published in a document called the Monthly Notices of the Royal Astronomical Society, and it came out on the 30th of March 2016, and it's entitled A Cloaking Device for Transiting Planets. And it's by two researchers called Kipping and Tichy from the Department of Astronomy at Columbia University in New York. The Monthly Notices is the longest established and most widely respected of publications in this field. Its editorial review policy is in the following terms, that I'm quoting. Manuscripts submitted undergo editorial review by the Royal Astronomical Society via a process of scholarly peer review. Each paper is assessed by a member of the editorial board, who in most cases will solicit the opinion of one or more experts, also called referees. Reviewers examine the content of the paper and they make recommendations on suitability for publication. Reviewers may choose whether to reveal their identity to the authors. The scientific editors are assisted by a team of assistant editors. At the end of this particular article, there's a rather comforting expression a comforting expression of gratitude by the authors to the reviewer, who in fact was anonymous. Now, in my view, there are 5 elementary points which one can draw from this. First, expert life could permeate the universe. Second, experts are really useful and amazingly clever, unless, of course, they lead to an alien invasion. Third, experts rapidly evolve evaluative techniques which are mind-expanding. Fourth, maths pervades everything, and alien experts are just as likely to use maths as our own experts are. Fifth, experts, certainly on this planet, adhere to high ethical and research-based standards, but upon the logical basis that this is recognized as the optimal way to enhance and disseminate knowledge. And it's not too far-fetched to surmise that for science to develop optimally in any self-aware, civilized society, the best research standards will be applied. I'd add one point to this. I think it's also a reasonable working assumption, but somewhere amongst that up to 10 billion exoplanets, Gallifrey, there will be room for disagreement. And there might therefore arise a need for dispute resolution. And if that is so on one of those 10 billion exoplanets, then alien judges might not be as good at the maths as the experts. I deduce from these observations that life is complex, experts are clever, but judges the universe over have some catching up to do. I refer to this generally as the information asymmetry. It's a point I will refer to later. So to the subject matter of this lecture. A recent Lord Chancellor from Earth notably observed, in the midst of some political spat or other about Europe, I seem to recollect, people in this country have had enough of experts. This led me to ask whether, even if it's true of the people, this was also true of the courts and the tribunals, given that we are now increasingly confronted with disputes which concern expert evidence about matters which are generally beyond the knowledge and understanding of the courts. My own experience on the bench It covers a range of cases involving technical evidence in both civil and indeed criminal fields. And this, coupled to my experience at the bar, has led me to the conclusion that if the courts, whether here or on Gallifrey, are to continue to serve their function as decision makers in the more complex cases, then we need to change the approach that we adopt. I think that changes are needed both on the part of parties, who must assume, in my view, a far greater share of the responsibility for reducing the scope of disputes, but also on the part of courts, to ensure that they are equipped with the tools and the skills to determine swiftly and efficiently increasingly complex disputes arising before them. Now, there are 3 points that I wish to make about this so-called knowledge asymmetry. My first point is really very simple. It is that the world is very, very complex, and it gets more convoluted technologically, economically, financially, day by day. My illustration based upon interstellar communication simply highlights this fact. The speed of technological advance is quite phenomenal, and the complexity which now routinely sits behind it, or which you find embedded in almost every service or good that is sold, and which drives modern economies, is so overwhelmingly specialized that it is beyond all but a few. The second point is that the complexity also encompasses the analytical techniques, those black boxes of tricks that are now routinely used to unlock the most seemingly intractable of technical problems. Now, more and more regulatory decisions, as everybody here knows, are, in quotes, evidence-based, which means that a wide range of quantitative, statistical, economic, and other techniques are routinely brought to bear on questions of identifying the right answer or the right policy to be applied. You only have to look at some of the more recherche impact assessments that the government publishes in some of the more esoteric areas to realize that even the government is using some fairly refined techniques in order to assist in policy making. Now, what flows from those first 2 points is the next point, which is that the courts have got to be able somehow to deal with the complexity of the subject matter and also the complexity of the expert techniques that are increasingly being deployed. Modern judicial doctrine accepts in a whole variety of different areas that courts have to apply up-to-date evidence, including scientific and technical evidence. It goes without saying that that is the norm in civil litigation, but increasingly in judicial reviews, the courts are told to roll their sleeves up and engage with complex evidence. My point, therefore, which underlies the thesis of my lecture this evening, is that this knowledge asymmetry between the world at large on the one hand and the courts and tribunals on the other has to be bridged in some way. At the heart of my concern is what I would call a concept of practical justiciability. And by this I mean no more than the intellectual or forensic ability of a court to form a considered and correct conclusion on the merits of a case. And to my mind, a case is not practically justiciable if the evidence is so complex and obscure, or the methods we are put before us to decide it are so difficult that we are unable to cope. Now, if this bridging does not occur, then I think over time, this will be bad for justice. It will be bad for the rule of law. Not every case has this level of complexity in it, but certainly from my own experience, and it's possibly because I dealt with a lot of technical cases when I was at the bar, the listing officers seem to think that I like statistics. Even in the last few weeks, when I was sitting doing a series of planning judicial reviews, they delighted in sending me those cases which turned upon whether local authorities had correctly applied some statistical analyses and whether the inferences to be drawn from statistics, in that case about housing need, were correct. But it isn't just competition law in which this level of complexity arises. If bad decisions are not addressed, then bad decision-making will continue. If bad decision-making continues, then you will have mal effects running throughout the economy. You will also have, unless the courts can lead the way, decision makers taking the view that second best will do. In short, rigour induces rigour, but vice versa also. Now, interestingly enough, the problem that I've identified is by no means new. I'm simply describing a mismatch between judicial capability on the one hand and technology on the other, which is perhaps increasing at the present time, but it's a dilemma that judges in the past have faced. In particular, judges in the 18th century faced exactly the same issue. The 1800s, or the 1700s, and indeed the 1600s, was an age of profound technological change. In the 1700s, Britain was the leading manufacturing and commercial nation in the world. An indication of the growth that occurred during that period was that the volume of shipping measured by way of tonnage entering the port of London increased 400% from 1700 to 1800. This was a period of the emergence of the metalworking industries in Birmingham and the Midlands, the growth of cheap cloth from the cotton mills of the north, and to fund this, the London markets developed ever more complicated financial instruments. And all of this was built upon a technological revolution led by mathematicians. So, for example, the philosopher, chemist, and mathematician Robert Boyle, 1627 to 1691, had a wish list. His wish list was for 24 inventions, and these included the prolongation of life, the art of flying, perpetual light, making armour light and extremely hard, a ship to sail in all winds, a ship not to be sunk, practical and certain ways of finding longitudes, potent drugs to alter or exalt imagination, waking memory and other functions, drugs to appease pain, procure innocent sleep, and harmless dreams. Now, all of these were essentially commercial aims, but he believed they were the progeny of science and maths. Isaac Newton, for example, 1624 to 1726, built the first reflecting telescope. He developed the theory of colour, premised upon the observations from a prism. So scientists and innovators developed a framework for much of the commercially developed technology during the period, and of course, litigation boomed. And so the judges had to be able to keep up with the research and to understand the problems arising. The chief enthusiast for using experts was Lord Mansfield, the Chief Justice between 1756 and 1788. He first sought to decide a body of commercial law by reference to the so-called law merchant. These were experts used in medieval Europe to decide commercial cases, and Mansfield was very keen on relying upon this body of continental law to try and codify it into common law, but it relied upon experts who decided cases. Mansfield also encouraged the admission of experts to give testimony in cases. In one rather entertaining case, the plaintiff asked the surgeon to cure him of a long-standing rupture. He paid the surgeon in 4 promissory notes amounting to 20 guineas. The surgeon was a quack. Litigation followed. An expert was called who testified that the plaintiff's condition was in fact a common puncture, and the total fees that should have been levied for this routine operation was 1 guinea. The jury found for the plaintiff and they awarded him 100 guineas by way of damages. Lord Mansfield also used experts outside of the formal special, experts in the jury system. Many commercial and civil cases were decided by juries, and he ensured that experts were on the juries to assist in deciding cases. Now, generally, he deprecated the practice of judges who would talk about their cases outside of the courtroom, but he himself was well known for going into the city to talk to bankers and insurers about the techniques and the markets of the time in order to help him decide precedent. Now that brings me to an illustration somewhat closer to home, which to my mind also highlights the operation of knowledge asymmetry. Now, over the course of my career, first as an academic, then in practice, I spent a lot of time in Luxembourg, and I came to learn that there was a single guiding principle which governed appeals and applications and cases involving technical expert evidence. And the simple principle was simply this: the applicant always loses. There are, of course, one or two honourable exceptions where the court found that the Commission made some egregious errors, generally of law or of procedure. I don't recollect ever concluding that an economic argument of any complexity, however meritorious, stood much chance of success, however hard one worked with the team to reduce it to the very barest of its quintessential essentials, to enable you to make it understandable to the court. As everybody here knows, to try and make something justiciable in the eyes of the court, you try and dress it up, you try and call it failure to address a relevant consideration or something like that, but such approaches rarely prevail. The more or less universal truth that applicants always lose prevailed, notwithstanding the repeated blandishments and statements by the court that it engaged in a detailed, sleeves rolled up analysis of the facts, not least to comply with the fundamental principles of the European Convention, which classified antitrust as penal law, to which higher standards of review were required. My own experience, and perhaps yours, was that the court was at best ill-equipped to deal with such arguments. The knowledge asymmetry was great. Two main factors, I think, lead to this conclusion. First, the judges are not selected because of their experience in economics or antitrust. Many, though not all, are often uncomfortable and unfamiliar with and unused to handling complex economic evidence. For this reason, there's always been an instinctive preference for neat, crisp rules of conduct in preference to context is all. Of course, as everybody here knows, there is a serious and legitimate debate to be had, and which has been had not only in the European Union, but in particular in the US, as to whether there is an acceptable trade-off between legal certainty, bright line rules, and economic purity, where context governs. There is indeed something to be said for having a rule which is invariable. It does facilitate business planning, it reduces litigation and regulatory risk. And the classic example of this from 50 years ago is the famous Arida-Turner test of predation, first articulated in the 60s, which sought to impose economically driven rules into antitrust and reconcile legal certainty with economics. But the concern, which is that nice, neat rules can lead to false negatives. In other words, conclusions that conduct is harmful when in fact it is beneficial or at worst neutral. And over the past decade or so, economists and other experts have refined their techniques, their black boxes, to the point where analytical tools generally exist which, to a high degree of probability and certainty, can indicate when conduct will be adverse or not. These black boxes get cleverer and cleverer, and the justification for rigid binary rules may thus have significantly weakened. Now, the second factor, which in my view has made the European courts ill-equipped to deal with complex issues, is that they don't have at their disposal appropriate procedural rules. Indeed, the procedural rules are simply not geared up to addressing the issues. It's not even recognised or acknowledged as a difficulty which needs addressing. There are numerous aspects of the procedure which, from the perspective of common law at least, I used to find most unsatisfactory. And I'm sure you're all very familiar with these. Expert evidence is not adduced or tested save on paper. There's no cross-examination. Where experts have a voice in court, it's been because the court invites the expert to come to the microphone and express an opinion. This has often been without any prior warning to the other parties. Indeed, it's not uncommon for the parties themselves to say to the court at the start of the case, we will call our expert in due course, and the court just accepts that person as a matter of course. When that happens, the experts invariably become advocates, they trespass frequently beyond their actual expertise, and no one questions competence or expertise. Therefore came as somewhat of a pleasant surprise to see the recent Advocate General's opinion in Intel. My last appeal to the General Court was in this case. This was litigation on a fairly stupendous scale. It involved a decision that Intel was guilty of abuse across the entire world, including for existence in China over an extended period of time. As I'm sure you know, the Commission decision was in large measure based upon the application of the AEC test. During the administrative proceedings before the Commission, a very high percentage of the work of the teams was devoted to economic and econometric analysis. The decision, when it finally came out, was held up by the Commissioner as the very model of good economic, evidence-based decision-making. The General Court, however, did not agree. It held that certain types of pricing conduct could be condemned more or less per se without resource to any economic analysis at all, and it did not bother to address the Commission's AEC appraisal. Advocate General Wall, on the 20th of October, just a few weeks ago, has expressed the opinion that in classifying certain types of rebate as more or less per se abusive, the General Court made a serious error in law. He stated, paragraph 90, I quote, "Experience and economic analysis do not unequivocally suggest that loyalty rebates are, as a rule, harmful or anti-competitive, even when offered by dominant undertakings. That is because rebates enhance rivalry, the very essence of competition." In paragraph 94, he said as follows in relation to modern economic literature. I think this is really quite an important starting point for an analysis. He said this: "Contemporary economic literature commonly emphasizes that the effects of exclusivity are context dependent. Conversely, few commentators would deny that loyalty rebates in particular can, depending on the circumstances, have an anti-competitive foreclosure effect." And later, para 132, he summarized the essence of the competing arguments advanced as to the approach adopted by the court. He said this, which neatly encapsulates the scope of the approach which the Advocate General thought was lacking on the part of the General Court. The appellant argues that the General Court erred in its analysis of the circumstances of the case by failing to consider the following circumstances. 1, the insufficient market coverage of the challenged rebates and payments. 2, the short duration of the challenged rebate. 3, market performance of competitors and declining prices. 4, the AEC test carried out by the Commission. The Advocate General rejected the submission of the Commission that these things were irrelevant, and he has suggested to the Court that they quash the General Court's judgment. Now, will the Court follow the Advocate General? Perhaps this is a watershed moment. The twists and turns in the approach of the treatment of expert analysis in Intel is, of course, by no means peculiar to competition law. It arises whenever the courts are asked to resolve really complex technical disputes, which are beyond the personal forensic skill set of the court itself. But it is an on-point illustration of the asymmetry of information and knowledge that can occur. Now, my Gallifreyan alien illustration was intended to highlight the two factors that, in my experience, lead to this asymmetry, namely the intrinsic complexity of the subject matter of a dispute and the commensurate complexity of the black box of expert techniques. Dealing in court with these twin pressures requires both the parties and the courts to modify their normal approach. And to my mind, for the parties, this entails two things. First, ensuring adherence to recognised best research practices, and second, adopting a more proactive approach in reducing the scope of issues. So let me just deal briefly with each of those two matters. Now, in relation to using recognised best practice, there's nothing new here. Both the civil procedure rules and, for that matter, the criminal procedure rules and the related practice directions contain detailed provisions which reflect these standards. Experts must assist the court on matters within their expertise. They must not trespass beyond their expertise. They should address relevant matters only, being those which are, quote, reasonably required to resolve the proceedings. Experts must be impartial. Experts must be even-handed. Experts must consider all relevant material, including adverse material. So what does that mean in practice? Let me take a few issues and spend a moment on them. First of all, conflict of interest and funding. Now, experts in law, of course, owe their primary duty to the court, not to the client. But by their nature, experts are at risk of being partisan only in the sense that they're instructed and paid by a party to put that party's case forward. This does not, in and of itself, mean that an expert is biased or incapable of acting impartially and fairly, but it does place a premium upon disclosure of interests which could create a conflict or an appearance of conflict. It's now standard practice for academic researchers in papers submitted to academic publications, such as the publication that I referred to at the outset, to declare their interests, including direct and indirect funding. Now, in commercial litigation, where professional experts are instructed, it's obvious they're being paid by the instructing party. But it's not common that their fees are revealed. Though, and this perhaps is reflective of a broader point, in these days of increased pre-trial cost capping, the experts' fees may well be disclosed in advance. This proves at least that the level of fees being paid is not an issue that could be argued to be confidential. It may well be thought that transparency is better. Next point concerns peer review. Peer review is a process whereby the world at large can scrutinise the output of research endeavour. In the article I referred to at the outset, the authors thanked the anonymous reviewer for his or her contribution. And the front rank of academic publications submit all submitted papers to peer review prior to acceptance for publication. Now, it may be rare in the context of litigation for experts to be able to submit a report to peer review before serving it in proceedings. It may be more common in the course of government consultations and in some types of litigation. But when an expert is expressing an opinion about an issue which is the subject of research and comment by others, then that expert should take that pre-existing literature base into account. That opinion should identify whether the literature that is being reviewed is itself peer-reviewed. This helps avoid what's become known as the echo chamber problem, which arises when experts seek to back up their own conclusion by reference to third-party research which is not independent and/or reviewed, and which supports their views. You simply increase the number of self-supporting echoes of your own view. An expert should acknowledge the existence of that literature base and address contrary opinions. And I think courts are entitled to take the view that an expert who deliberately avoids the material is not acting in accordance with his or her duty to address relevant evidence. Assumptions. In many, if not most cases, experts' conclusions will be based upon assumptions. Now, in many cases, you, the lawyers, may give those factual assumptions to your experts and you will state them in the letter of instruction, and they're there transparently for the world to see. In some cases, the assumptions will be derived by the experts themselves. For a court, the assumptions will rarely be transparent unless the expert sets them out in a comprehensive and understandable form. In my view, clarity is important for two reasons. First, because without transparency, the court and opposing parties cannot test or verify the correctness of the opposing expert's ultimate opinion. But secondly, because if the assumptions are hidden from view, the court may be entitled or driven to the conclusion that the opinion has not been verified, and it may therefore be treated as suspect and not accorded full probative weight. In my view, there's no reason why a court should be placed in a worse position than economic regulators are. And you have a benchmark in the economic regulatory world which we can take as a benchmark for our own analysis. Regulators invariably require expert evidence to be submitted to full verification, and this can entail disclosure of the underlying software and algorithms upon which all modelling is based. Regulators invariably reject a suggestion that there are no assumptions underlying an analysis. For instance, the integrity of regression analysis, which is increasingly used as a valuable tool in regulatory decisions and in litigation, has been recognised in the literature, but also by regulators, as being a function of its verifiability. Now, being transparent in this regard enables courts to know whether the assumptions accord with real life or are based upon false notions or skewed statistics. To my mind, it's important that if transparency is the norm, it provides an ex ante incentive on the expert to ensure accuracy in the first place. The prospect of being successfully cross-examined on assumptions and having to conclude that they're inaccurate or incomplete or out of date or based on non-peer-reviewed literature will encourage experts to be robust from the outset. There are, of course, many ways in which transparency can be achieved. My own experience is that the best reports will set out, often simply listing them, the various assumptions that are made in non-technical and readily understandable terms. Which brings me to maths. Maths should be avoided wherever possible. I once heard an American judge at an antitrust conference in New York, it was in Fordham, express the view with only half of her tongue in her cheek that any party who used maths had to lose. I have a clear recollection of seeking to advance an argument to the General Court in Luxembourg that I thought was extremely simple and straightforward. I refined my submissions on this simple maths to the point where, when the judges came to look at the transcript afterwards, I thought they'll find it blindingly obvious. I was deluded. As I explained the point, it was blindingly apparent that they were implacably hostile to the argument simply because it was presented as maths. The submission I was making was incontrovertible. The Commission did not even attempt to question the maths. Their tactic was to circumvent. The point was skirted round and was ignored in judgment. You use maths at your peril. But I think I should be very clear about this. I can see no conceivable justification for a court taking the view that maths is non-justiciable. Where in any administrative or regulatory proceedings, if an outcome, an impugned decision, depends for its logic or its reasoning upon maths, then it simply has to be the duty of the court, one way or another, to find a way to resolve the dispute. I gave an example in one judicial review involving gambling and Gibraltar of a decision which turned upon the application of a mathematical formula where there'd been an error in the placing of a decimal point, 1 point to the right. It's easy in such a case to see that the end result, or a substantial portion of it, might be out by a factor of 10, and that could plainly be a material error. Now, a judge or a court might experience extreme difficulty in locating this error, perhaps because it's somewhere embedded in the fourth equation down on page 9 of Schedule 17. And then even greater difficulty in understanding it, but that does not mean that the error, objectively speaking, is not serious, or once unearthed, should not lead to the proper outcome. To my mind, it is the duty of the court to ensure practical justiciability in the sense I've referred to. Internal documents. This is a further aspect of verifiability, and it's the importance of being able to benchmark an expert's opinion against practical reality. This is often not a real issue because in ordinary civil litigation, experts don't prepare their opinions until after disclosure. And in regulatory proceedings, regulators have powers to require access to documents or conduct dawn raids in order to unearth both the inculpatory and exculpatory material. But in some circumstances where you don't have disclosure, one needs to avoid the risk that experts can express an opinion without having those opinions benchmarked against internal documents. And litigation lawyers here will know that it is often your clients, the middle and senior managers, who are the greatest experts of all, and it is in their internal emails that they start to really debate the ins and the outs, the ups and the downs, the rights and the wrongs of a particular issue. Reputations. Frequently as judges we hear cases where experts of the most remarkable pedigree are called to give evidence. In my experience, it can be a real joy and indeed a privilege to have such doyens in court. One of the very first cases involving technical evidence that I heard, which was in my first term as a judge, occurred when the listing officer, Tim Green, walked into my room. I see Ian's here. He said, "Sir, I've got a case for you." He said, "If I were Ian, I'd be walking in and saying it's a lovely case in Hong Kong, first class travel and a 5-star hotel, but I'm afraid it's not." He says, "It's ghastly. It's going to run into the Christmas vacation. Oh, and it starts tomorrow. The mother died in childbirth. The baby, terrible, terrible injuries. And it's all about whether the administration of a second dose of a drug was negligent. Oh, by the way, there are 8 experts." So I said, oh, why not? Sounds great, it sounds wonderful fun. I saw the papers and I immediately got onto medical Wikipedia. By the following morning, I knew all about the uterus and uterine ruptures. And I had a fair amount of knowledge about the particular drugs designed to facilitate birth and prevent uterine rupture. I had 8 experts, some of whom were just quite fabulous. And it was an absolute joy to listen to them. One of the experts, whose opinion ultimately I rejected because she applied too high a standard for the negligence test, was precisely the person I would wish to have treating me if I had any sort of a problem at all. They were wonderful. They valued their reputations. They gave a lot away in cross-examination. When they felt they had to, they stuck to their guns, and you felt as a judge you could trust their opinions because they were balanced and amazingly professional. A Nobel Prize winner who's instructed in a case is not necessarily right just because he or she has been honoured by the Swedish Academy. The work of such a person might be astonishingly sophisticated, but if it doesn't adhere to best international standards because it's not peer-reviewed or it's not independent, then it might actually be given lesser probative value than the other side's expert who is not of the same outstanding pedigree, but who simply sticks to the rules. So adherence to standards should be a norm, and if an expert doesn't stick to standards, I can see no reason why, in a closely balanced case, a judge shouldn't say, I have 2 experts, very difficult to decide who I prefer, but one category of experts does adhere to standards and the other doesn't, and that might be decisive. On the other hand, a court which is compelled to choose between experts on that basis is engaged in a second best exercise, because a non-adhering expert might still be right. It would, in my view, be unfortunate if non-adherence to standards became a proxy for a conclusion that the opinion of an expert was not sound or robust. Now, when you do get adherence to high standards, of course, that doesn't make the task of the court easy. The task of evaluating competes of impeccably prepared expert evidence is daunting. So I now turn to the question of how the parties should take responsibility for boiling down the issues. Now, I emphasize this because it's something I feel very strongly about. This is as important for specialist courts and tribunals as it is for non-specialist forums. I've talked about an information asymmetry. There is a familiarization gulf or asymmetry between the parties and a court. You will have spent months, if not years, working with the experts, and you will have acquired, over that time, a deep understanding of the issues and the arguments. And I know from experience that what may seem perfectly obvious to the advocates after months of hard work may be very far indeed from clear to a court upon first contact and encounter. And that's as true for specialist courts as it is for non-specialist courts. We are not given the amount of time that we always need to study and absorb the expert evidence. And even if we have a decent dollop of time before a case, we can't spend it all on the experts, because it might only be 30% of the total volume of material we have to read and understand. And we do not have the distinct advantage that you have of being able to talk it through with the team. And that sense of conducting an isolated exercise is heightened once the case is finished and we go away to write a judgment. This imbalance has to be recognised, understood and catered for. Now, in the British American tobacco case, which I heard earlier this year and which was in the Court of Appeal just a few weeks ago, I had an opportunity to express my concerns, which had been brewing not just in that case, but over a number of cases where I'd been asked to grapple with complex material. And over that period, this question of the imbalance between the court's ability to grapple with something and the parties' familiarisation with it and their desire to have it adjudicated on was acute. The key to this, and to ensuring that that imbalance doesn't lead to injustice, lies with the parties and the experts accepting that they owe their primary duty to the court and eschewing gaming expert evidence processes. The earlier the experts, encouraged by legal teams, engage with each other to drill deeply into the issues and identify those that are key and material, the better. And it's obvious that one side, sometimes all, has a forensic advantage not to do this because obfuscation might be the tactical order of the day. But that's not good enough. Rules require active cooperation with courts by both lawyers and the experts. Now, in BAT, I set out various steps that, in my view, I thought properly adapted to meet the exigencies of any particular case could enable us better to deal with the arguments you wish us to deal with. And I summarised various steps in paragraph 633 onwards upon the premise that there was a need for a process-driven solution to this conundrum. Let me very briefly summarise those steps and make one or two observations, practical comments about them. First, parties should encourage their experts, and I say the parties should because it's the lawyers and the clients that have control over this, obviously with court pressure, but it's the parties that have control over this, and they should require the experts to engage with each other at the earliest possible chance in order to identify the key issues. And then, for the experts to consider how the evidence should be presented and addressed by the court. Now, in my view, the parties should not await the first case management hearings. The parties should be able to recommend sensible issue reduction steps the first time they go in front of a court. I would expect the process of expert engagement to more or less eliminate disputes about maths, because if there is a dispute in which the issue is was the decimal point one place wrongly to the right, the expert should be able to agree that. So the maths should largely be eliminated. So, for example, if the dispute is as to whether a decision is based upon conclusions derived mathematically, one would expect to see an agreed statement. Now, if there isn't, of course, there may be a good reason for it. I'm not saying this must be an inexorable rule, but it should be rare that we are asked to resolve mathematical issues. Now, secondly, the expert should meet and identify the areas in dispute, and they should then start a formal process of listing areas of agreement and disagreement. It's important that this process needs to be properly recorded. Remember, we have to produce a judgment at the end of the day, and quite often if you've got agreed facts, it's very useful for the judge to be able to annex them to a judgment, and that enables other experts, other lawyers, other practitioners to see how the process worked, and it can save a lot of time. Third, I think that in every area of agreement there's a very, very important next step, which is for the experts to agree which are material and which are not. As we all know, there may be, and there often are, many, many issues that we fight about in court, and 3/4 of the way through the trial we realise that actually half the issues don't matter two hoots. If those immaterial disputed issues had been highlighted through a process of rigorous engagement at the outset, they could be discarded. Now, one accepts that there are uncertainties in trial processes and something might have to be resurrected at a later stage. But if the experts agree on materiality, you can whittle down the scope of the disagreement to a much, much smaller compass. I think then the experts not only need to identify what are the material disputes, but even within the ambit of material disputes, there are degrees. There are some disputes which are material, but may not be as fundamental as other disputes. The next thing is for the experts to set out why they disagree and to provide their brief, concise critique of the other side's opinion. Assumptions need to be set out. If we've whittled the process down from a wide ambit to a narrow ambit, the number of assumptions, the amount of work that should now be performed should be substantially reduced. Fifth, and this is where I think it's important that the experts not only concentrate on narrowing issues, but then provide assistance to the court. The experts should identify, now perhaps assisted by the legal representatives who may not be involved at an earlier stage because it might risk impugning the expert's impartiality, but there comes a point where the lawyers may need to work with the experts to identify and then list all the documents or pieces of evidence which are relevant to this small group of residual disputes. Sixth, the experts should set out the opinion on what the court must decide and how this can be achieved. It's commonplace for issues which appear complex ultimately to turn upon very narrow issues of fact. For example, it may be the issue turns upon the construction of a contract or the inferences to be drawn from a single piece of literature. I recall in one case that an issue was whether a cost was to be treated as fixed or variable, and the evidence relating to this turned upon a dispute over the period of time over which the cost should be amortized. And the evidence for this was no more than 3 pieces of literature which provided information as to how investment on innovation in the particular sector occurred. Once it was agreed that this was the key evidence, the actual factual dispute was easy to resolve. And once one had decided whether a cost was fixed or variable, then as you will understand, the implication of that finding could have a substantial outcome on a predatory pricing case. The next 7th point is that the entire process has to be recorded in a single composite document, or if necessary, if it's practical, a series of documents. This provides the court with the record, but, and I think this is very important, it enables a limit to be set upon the documentary evidence that is then placed before the court. And that, of course, may be very important in terms of limiting the scope of disclosure. Finally, and perhaps formulaically, experts must comply with the wording and spirit in civil cases of CPR 35. Courts must be confident that experts are aware that their overriding and primary duty is to the court, and the awareness feeds constructively into this perhaps more expert-driven approach that's contemplated. I don't think I fully understood this when I was at the bar, but it becomes much more live when you're dealing with experts and not just expert declarations, but witnesses of fact on a daily basis. Declarations in witness statements are not mere mantra. They should be viewed as a statement that the expert takes seriously his or her obligations. Now, it's important to emphasize in all of this that I'm not saying that experts simply have to roll over. They walk a difficult line between their responsibilities for their client and their duty to the court. And that's understood by the courts. We're not expecting them to be completely and totally neutral. They're there to advance a position, but they are generally well versed in managing that difficult balancing exercise. Let me turn to the judicial role, which is the other side of the coin. I've got 3 points to make. This is the counterpart to the efforts to be made by the parties. We've got the procedural rules and the CPR. We need to use them. First, I think we need to be more proactive, ensuring that parties address themselves to the issue of constraining expert evidence. This implies early case management, and it requires the parties at an early stage to inform the court as to the steps they propose to take to boil the issues down. If courts trust litigants, then there are real benefits. One, The size of expert reports should be substantially reduced because before the experts commence on the really hard work of drafting their reports, they will have engaged in a process of pulverization of issues. They will have identified the key issues and their drafting remit will be much more focused and targeted than it would otherwise be. And I'm sure you, like I, have all seen experts' reports which range far and wide and which go 40, 50, 60, 70, 80% beyond the true issues in a case. Second, disclosure may be substantially reduced by such an exercise, which saves costs and shortens litigation timetables. And of course, few of your clients enjoy disclosure, so they may welcome this. Point 3, settlements may be encouraged because there will be earlier engagement with the real issues in a case, and the parties will be assisted in the process of forming a realistic view on merits. And this hopefully will also be because the process should lead the parties to conclude that the court is ultimately more likely to reach a fair and right answer. And more generally, if these sorts of approaches are more routinely taken, parties should feel confident that they can bring cases of real complexity to the courts in the knowledge that the courts will be able to resolve them. 2 more points before concluding. Assessors. The next point relates to the task of the court in exercising independent judgment over the extent to which experts have in fact gone that extra mile to reduce the scope of a dispute. And I think in this connection, the use of court-appointed experts or assessors is a potential tool that is available to us and perhaps is not as widely used as it is, certainly outside of the Patents Court. The power to appoint assessors exists in the Senior Courts Act, section 70, subsection 1, and the CPR 3515. The court can consider the appointment of an expert or an assessor in a very wide range of circumstances where and it would include where it's considered that there is further scope for a boiling down exercise at the end of a process undertaken by the parties. The power might be exercised by a court because it isn't satisfied that the parties, or one of them, has shown sufficient enthusiasm for the process. There's also scope to appoint an expert to act as a teacher. A recent illustration in the Patent Court is found in the judgment of Mr Justice Burse in Electromagnetics Geoservices earlier this year. In that case, the judge ordered the appointment of a specialist scientist to provide a non-controversial one-day introductory teach-in for him. And he gave a final judgment at the end of the case in which he explained how extremely useful the teach-in had been. The judgment is a really very useful explanation of how and why the use of third-party assessors or experts can save court time and costs and lead to better results. Finally, hot tubbing. Hot tubbing is sometimes more prosaically known as concurrent expert evidence. This refers to the practice of hearing evidence from experts in a particular discipline at the same time. The practice took root in the Competition Tribunal in Australia. It was subsequently adopted by the Supreme Court of New South Wales. The experts were required pre-trial to meet in order to identify where they agreed and disagreed, and then in the course of the trial, experts in the same discipline were sworn in at the same time, and then the judge effectively then chaired discussions between them. The pre-trial document recording the matters upon which the experts disagreed served as the agenda. Counsel participated in the discussion. They were entitled to question the experts, but only when the judge so allowed. According to a talk given by Lord Justice Jackson on this topic on the 29th of June of this year at the London Conference of the Commercial Bar Association of Victoria, the procedure is now widely spread throughout the entirety of the Australian judicial system and has now been adopted into the federal procedural rules. The experience in Australia indicates that the practice is effective in saving time and costs, and it repatriates to experts their proper role in assisting the court. It does away with gladiatorial combat between cross-examining counsel. Now, this practice has started to take root in this jurisdiction. A number of judges in the Technology and Construction Court now regularly use hot tubbing. For some judges, this is now the rule, not the exception. The experience of the TCC judges is that experts engage very well with each other and in court debate points constructively, often to the exclusion of lawyers who then participate as no more than interested onlookers. The practice has been used on a few occasions in the Chancery Division, and I obviously used it in Street Map, as reported in a judgment that I don't remember earlier this year. During May of this year, a major set of construction chambers were asked to conduct a poll of their members as to their experience. There were 15 responses. 7 respondents spoke favourably or very favourably of the process in construction, litigation and arbitration. 3 were hostile. One response apparently said he didn't know what hot tubbing was. I have some limited experience myself of hot tubbing whilst in practice, not as a judge. The one thing I would say is that for hot tubbing to be effective, it presupposes that the judge is really on top of the technical detail before the hot tubbing exercise starts. Well, ladies and gentlemen, I've dealt with everything that I wish to deal with about experts from the perspective of the parties and the court. And that brings me really to a conclusion. And I wish to conclude with just a few words about the man whose name adorns this lecture. Blimey, I thought I'd forgotten it for a moment. Now, if my hypothesis about Gallifrey is correct, then somewhere out there, possibly maybe 1,000 light years away, there is a court in which the Gallifreyan equivalent of David Vaughan, Queen's Counsel, is presently making submissions. He will be a mirror to the earthbound version that we see before us this evening. Accordingly, that Gallifreyan advocate will exhibit and exude joie de vivre. He will leave and have in his wake a string of triumphs in cases which have left their mark on the Gallifreyan constitution and upon intercontinental laws and their own economic unions therein. He will be a force to behold in court. His oratory will be a heady mix of humour coupled with an uncanny instinct to sniff out a good point, often a point that no one else has thought of. He will also have the appetite of a bon viveur. His Gallifreyan juniors will relish cases with him because they always entail a fabulous meal after the case, whether win or lose. That Gallifreyan David Vaughan is a true expert, and so, of course, is ours. Thank you very much, ladies and gentlemen.
Well, apart from the conclusion, I'd like to thank Nick very much indeed for the extraordinarily erudite and interesting talk. I'm not sure whether in fact what we want to do now. Do you want to have questions or do you want to drink?
I think we should drink, but can I just add one small and vaguely relevant PS? The last bit of Nick's presentation reminded me that I have the honour of being the person who explained the concept of hot tubbing to David, I don't know, 10, 15 years ago.
You refused to join
when
me.
he was you've never ruined the joke, but I did, and Nick was actually the, thank you.
Were birch twigs involved?
It involved both of them, actually. Yeah, there was an arbitration.
No one from the Daily Mail here, is there?
No, but I mean, there was a conversation involving whether or not the pair of them had to get into a jacuzzi. With or without me, I don't know. But I did say that was unnecessary. Anyway, thank you again, and we do have drinks outside. Thank you.
Thank you very much.